The last couple of months have been an extremely good time for marriage equality here in the United States. In early July, a pair of rulings out of the United States District Court for the District of Massachusetts struck down key provisions of the Federal Defense of Marriage Act as unconstitutional. And just a few days ago, on Wednesday, August 4th, a ruling out of the United States District Court for the Northern District of California said that Proposition 8, a voter-enacted amendment to the California state constitution, which said, quote, only marriage between a man and a woman is valid and recognized in California, violated the due process and equal protection clauses of the 14th Amendment to the United States Constitution. That case is Perry v. Schwarzenegger, which is something of a misnomer because California's Governor Arnold Schwarzenegger and the other California government officials who were named defendants in the case refused to defend Proposition 8 in court. In fact, California's Attorney General Jerry Brown went so far as to concede that Proposition 8 was unconstitutional, and the city and county of San Francisco intervened in the case on the side of the plaintiffs, those challenging Proposition 8's constitutionality. The proponents of Proposition 8 during the 2008 election cycle were granted leave to enter the case to defend its constitutionality. The judge in the case was Vaughn R. Walker, Chief Judge of the District Court in California. He was nominated to the federal bench by Ronald Reagan in 1987. That's right, Ronald Reagan, but Walker wasn't confirmed until a couple of years later during the administration of George H.W. Bush. Since the publication of Judge Walker's ruling, many of the more prominent, bigoted, and bitter supporters of Proposition 8 have tried to call the merits of the decision into question by pointing out that Judge Walker is a homosexual.
Oh my God.
For example, Christian right leader Charles Colson posted the following on his website breakpoint.org, quote, inasmuch as Walker is one of the few openly gay federal judges, maybe his decision shouldn't shock us. On its website, the so-called National Organization for Marriage screeched, quote, an openly gay judge in San Francisco ruled that his imperial voice trumps the voice of the people. Get it? Imperial, Empress, Queen. Tony Perkins of the Family Research Council.
One judge who thinks he knows, and a district level judge, and an openly homosexual judge at that.
Pat Robertson.
Judicial activist, one homosexual judge. One homosexual judge.
Old Pat Buchanan.
Oh, well, yeah.
And he happened to be gay. That might have had something to do with it.
Has nothing to do with it.
William Lane Craig.
And Judge Walker, who is one of three openly homosexual judges, federal judges in the United States, ruled in favor of the plaintiffs.
By the way, I posted a question about this on Dr. Craig's website. We'll see if he answers. It's disheartening to see comments on Dr. Craig's website defending this blatant ad hominem and bigotry, alleging that a gay judge's sexual orientation, quote, might cloud his thinking, and that a, quote, homosexual has a vested interest in the outcome of this case, and therefore a, quote, conflict of interest that necessarily renders him or her unable to judge impartially. Not that long ago in our history, bigots used to say precisely the same things about female and African American judges presiding over employment discrimination and other civil rights cases. Bigotry never really changes. Another drum being banged by the Christian right and the right wing generally is the allegation that the Perry decision is an affront to American democracy.
7 million Californians believed that we had a core civil right to organize, to donate, to vote for marriage. One judge in federal judge in San Francisco has stripped us of that core civil right.
Just about whenever the right wing loses in court, and it's been losing a lot lately, its members carry on as if the United States were the functional equivalent of ancient Athens, direct majoritarian democracy, and the judicial branch of government were some totalitarian plot. The truth is that the United States is, of course, a liberal democratic republic, and one of the distinguishing features of its governance is the attempt to empower and employ a powerful national government to protect individual rights and liberties against the tyrannical tendencies of majorities while preserving the spirit and form of popular government. The judicial branch is central to this project. In 1943, in the case West Virginia School Board v. Barnett, one of my favorite Supreme Court decisions, Justice Robert Jackson wrote for the court's majority, quote, "The very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities, and to establish them as legal principles to be applied by the courts. One's right to life, liberty, and property, and other fundamental rights may not be submitted to a vote. They depend on the outcome of no elections." Judge Walker incorporated this into the Perry decision, quote, "that the majority of California voters supported Proposition 8 is irrelevant, as fundamental rights may not be submitted to a vote. They depend on the outcome of no elections." Are the characters who lead the Christian right unaware of the judicial branch's obligations? No, they know about all of this. But they will say anything in an attempt to win. Let me suggest two related reasons why the Christian right is misrepresenting this key basic of American government. First, they want to keep this matter in the political process because they know that the fundamental rights of lesbian and gay Americans, an unpopular minority, tend not to fare well there. Between 1972 and 2005, 71% of local and state gay civil rights initiatives and referenda resulted in losses for minority rights. Approximately 90% of those measures were significant in that they addressed questions of fundamental rights. Now, narrow the focus to measures involving only the fundamental right to marry, and the lesbian and gay cause pretty much never wins when the issue is decided in state ballot contests. Second, and related, the Christian right knows that public opinion is shifting against them on this issue, and therefore they have limited time to get their opposition to same-sex couples marrying enshrined in the law. Attorney Evan Wolfson, an advocate for marriage equality, summed it up nicely on CNN.
Well, actually, the proof that the National Organization for Marriage and the millions of dollars they funnel into these campaigns don't believe that they have the best arguments. And the reason that we know that they do fear that public opinion is moving in the direction of fairness is that they're trying to cement these discriminatory barriers into constitutions to prevent legislatures, to prevent the people from making a decision to end this discrimination this year, next year, or in the future.
The desperately frenzied ad hominem fear-mongering lies and inflammatory rhetoric of the Christian right aside, I'd like to spend the next few minutes examining the decision in Perry v. Schwarzenegger. Plaintiffs in this case, same-sex couples in California who'd been denied marriage licenses after Proposition 8 went into effect, argued that Proposition 8 violated the 14th Amendment's due process and equal protection clauses. And as noted earlier, the judge ruled in their favor on both counts. Let's look at each separately. First, due process. The United States Constitution's due process clause, actually there are two due process clauses, one in the Fifth Amendment, which applies to the federal government, and the other in the 14th Amendment, which applies to the states and their political subdivisions. The due process clause protects against arbitrary governmental action that denies persons life, liberty, and or property. When, for example, government acts in a way that burdens people's exercise of a fundamental right, the most important and highly protected rights we have, this creates a potential due process problem because the word liberty in the clause is understood to protect, among other things, the exercise of fundamental rights. These are rights that, as the courts have said, are inherent or implicit in the concept of liberty itself. In other words, governments improperly denying someone's exercise of a fundamental right is a denial of liberty. In the instant case, the fundamental right at issue is the right to marry. Relying on a long and consistent line of Supreme Court precedent, Judge Walker said, quote, "The freedom to marry is recognized as a fundamental right protected by the Due Process Clause. Now, here on YouTube and in real life, I've often encountered ideologues and ignoramuses who insist that there's no legal right to marry, and even if there is, it's not a fundamental right. If any of them are watching, and I know you are, they should take note of the fact that in Perry, the proponents of Proposition 8, those who supported it and defended it in court, quote, do not dispute that the right to marry is fundamental. And that's good, because there's nothing to dispute. Plaintiff same-sex couples charged that Proposition 8 precluded their exercising the fundamental right to marry. So, when a law burdening the exercise of a fundamental right is challenged on due process grounds, the court uses what is called the strict scrutiny test in order to determine whether in fact the challenged law violates the Due Process Clause. Under this test, a law will be upheld as constitutional only if it is necessary to achieve a compelling or overriding government purpose. The burden of proof is on the government as the party defending the restriction to show that it's necessary to achieve a compelling government purpose. The proponents of Proposition 8 argued that it should be evaluated by its consistency with the, quote, central purpose of marriage in California and everywhere else, to promote naturally procreative sexual relationships and to channel them into stable, enduring unions for the sake of producing and raising the next generation. Just an aside here, about a year ago I did a video entitled, It's All About Children, or at least the anatomical possibility thereof, that deals with this argument in great detail. There's a link to it in the description box below. Since same-sex relationships are not inherently procreative, proponents claimed, marriage is not implicit or inherent in the concept of liberty for same-sex couples. Judge Walker found that the root of the problem for proponents' claim was that they'd failed to make a due process case to support it. They simply did not prove that channeling, quote, naturally procreative sexual relationships into marriage was California's compelling reason for preventing same-sex couples from marrying. Perhaps the quintessential example of this failure is described by Judge Walker as follows. Quote, the court posed to proponents' counsel the assumption that the state's interest in marriage is procreative and inquired how permitting same-sex marriage impairs or adversely affects that interest. Counsel replied that the inquiry was not the legally relevant question, but when pressed for an answer, counsel replied, Your Honor, my answer is, I don't know. I don't know. Again and again in this decision, Judge Walker shows that proponents failed to make a case to support their claims, and ultimately he concluded, as any reasonable person should conclude in the face of such failure, proponents didn't make their case because proponents couldn't make their case. They had no legal case to make. This decision reveals the bankruptcy of the legal case against allowing same-sex couples to marry. Judge Walker found, quote, never has the state inquired into the procreative capacity or intent before issuing a marriage license. This is an odd, compelling interest that the state doesn't even inquire into. Worse yet for this claim, the state issues marriage licenses to opposite-sex couples who can't procreate. Moreover, even if this were a compelling government interest, proponents failed to show how preventing same-sex couples from marrying was necessary to achieving it. Judge Walker was constrained to conclude that denying homosexuals the right to marry was not necessary to achieve any compelling interest of the states, and therefore, Proposition 8 violated the Due Process Clause. I'll turn to equal protection in Part 2. Thanks.